All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated.
Okay, good afternoon to all. Let's call the case for argument.
Chief Justice, Justices, and may it please the court, I'd like to request 2 minutes for rebuttal.
It's granted your request, so please proceed, counsel.
Thank you. My name is Taylor Phillips, and I, alongside co-counsel Mr. Tyler Gustafson, represent Mr. Saylor, the petitioner in today's case. I will explain that the WTP tokens are not a security, and Mr. Gustafson will explain that culpable participation must be pled here. As securities are economic in nature, Congress intended for the application of securities law to turn on the economic realities underlying a product. Therefore, to hold that the WTP tokens are a security would expand the scope of the acts to include virtually any product that has some form of profit attached to it. Accordingly, this court should reverse the 13th Circuit's decision because the WTP tokens are not a security for 2 reasons. First, the donors purchased the tokens primarily for consumptive use. And second, the donors directed and controlled Declaration DAO. This court in SEC versus Howey established the Howey test, which is a 3-pronged test to determine whether a product at issue qualifies as an investment contract so that it may be regulated under securities law. The 3 prongs are: first, an investment of money; second, in a common enterprise; and third, there must be an expectation of profits from the efforts of others. It's the
Counsel, let me ask you, out of these factors that you were discussing, which ones does your client meet, and which specifically is the factor or factors that do not apply to your client for purpose of your analysis under Howey?
Chief Justice, the first prong is conceded that it's met, but the second and third prong are at issue in this case, and the burden is on the SEC to meet every element of this test. The Howey test specifically applies to profit-seeking ventures, and the line was drawn by this court where there is a consumptive motivation that substantially outweighs a profit motivation, then it's not going to be a security, and that was stated in United Housing Foundation versus Foreman. Congress did not intend that in the name of protecting investors, that the SEC should be able to interfere with the ability to enjoy the ownership and the use of a product. Which brings me to my first point regarding—
Counselor, can I ask you a question? The purpose of Declaration DAO was not to make a profit?
Your Honor, the purpose of Declaration DAO is clear from the white papers on pages 6 and 7 that Declaration DAO was to be political, not economical. It was to attract those who support American democratic values, to put the Declaration of Independence into the hands of the people, and to provide a forum of democratic ownership. And further, the white papers were clear that this was a nonprofit organization, and the SEC conceded that on page 4 of the record. If this was a crypto coin, then it would substantially be for profit. However, this is a crypto token. There's much more to it than just monetary value. It has ownership rights and voting rights. The word donor that is stated on the white papers makes it clear that a reasonable purchaser would expect to give money and not receive money. And so in that way, the WTP tokens and Declaration DAO here are very similar to a crypto GoFundMe.
I understand. Why don't you continue, if you'd be so kind to continue answering Chief Justice Gelpi's question about how this 3-part Howey test is satisfied or not satisfied. Thank you.
Yes, Your Honor. So the point that I'm making is going to the expectation of profit. So the second and third prong are not met here. And specifically with the third prong, with the expectation of profits, there was substantially a consumptive motive here that outweighs the profit motive. There was no explicit statement that donors would receive profits or dividends or payouts. And there's district court cases coming from the Southern District of New York, where the New York Stock Exchange sits, and the Northern District of California, where Silicon Valley is located, that are factually similar to here. And those—
Counsel, if I may ask a question, please. Despite what you just said about profits, didn't Declaration DAO's objectives state that their purchase was essentially in exchange for a return on investment? What is your response to that?
Justice Parker, the white paper did not say that, and neither did the custodians to purchasers of Declaration DAO. The purpose was to be political, to put the hands of the document into the hand, or put the document into the hands of the people. It was democratic ownership over one of America's founding documents. On page 3 of the record, it states that usually when it comes to the Declaration of Independence, it's usually owned by private wealthy individuals or institutions. And so Declaration DAO is offering a unique ability for citizens to be able to take ownership over this important document. And further, there was no explicit statement that donors would receive profits or dividends or payouts from Declaration DAO to the donors. And going back to those district court cases, those courts found that in a crypto token-based enterprise, that if there is an explicit statement, that's going to put an expectation that they're going to receive profits, and that profit motivation will substantially outweigh any consumptive motive. And also similarly to Foreman, the token holders here had the ability to refund the tokens for the amount that they originally purchased, and therefore there was no financial risk aspect. Securities law is meant to apply to profit investments to specifically protect investors. This token was primarily purchased by donors for a consumptive purpose and therefore does not fall within securities law. A few other examples are when a person buys a house or when a person buys a piece of art. The average consumer is buying a house to be able to live in it, even though there is some profit motivation on a sale later. At the time of sale, the primary purpose is to consume or to use the house. And the same is with a piece of art. When a person buys a piece of art, they're primarily buying it at the time of sale to be able to have it as decoration for their home, to enjoy it. And so that's similar to here. If this court states that these tokens are security, then even transactions that have a substantial consumptive motive would fall under securities law and hinder markets like buying a home or buying a piece of art, because that would discourage sellers to want to put their products on the market, which would have a detrimental impact on markets for the average consumer, which is exactly the person that the acts were designed to protect.
Counsel, sorry. What do you account for the fact that this was an auction and the donors, as you call them, were notified that their auction, the bid, may not be successful? So what of the fact that if the bid was unsuccessful and they were not going to be obtaining the declaration, essentially, that they could be using the tokens for something else? Isn't it possible that even if their motives were at once consumptive, that their motive could change to one of expected profit, especially if their bid was ultimately unsuccessful?
Justice Momo, the papers were clear that if they didn't win the bid, then it would be the donors who would be able to pick what new business venture or project that Declaration DAO would take on. And Declaration DAO did say that it would be something similar to the Declaration of Independence. For example, perhaps a replica of the Liberty Bell. However, it's the donors that were the ones who were able to control that, not the custodians here, which actually brings me to my second point. The donors here controlled Declaration DAO, and this goes both towards the second and the third prong of Howey. And there's a circuit split with the second prong of Howey. However, under any of the commonalities that this court applies, the facts of this case do not satisfy those commonalities. And I will focus specifically on vertical commonality, which the 13th Circuit has adopted. The donors here were not dependent on the custodians because the donors had actual practical ability to exercise management rights and control over the organization. And so this was not an investment contract. Or in other words, the greater the control that donors have, the less likely it is going to be a security. And here, the donors had the ability to direct and control declaration DAO because they had voting rights. Custodians did not have voting rights. The white paper was clear that the donors could vote the custodians out. Therefore, the custodians were expendable. The token holders had these substantive decisions and the ability to make those decisions. They could vote and they could submit proposals if the Declaration of Independence was not won at the bid, and they would be able to vote on which proposal would be accepted and taken, and therefore direct the path of Declaration DAO. And so token holders were able to control Declaration DAO just like they would have been able to control the placement of the Declaration of Independence. The structure of this organization directly reflects the purpose of democratic ownership. And further, this case is distinguishable from SEC versus Howey, which is controlling here. In SEC versus Howey, the management company exercised significant control. They were the only ones who could manage the orange groves, and they were the only ones who could provide equipment for those orange groves. And so the investors there were heavily dependent on those managers. However, here, the custodians were performing ministerial tasks at best. All they did was oversee the ether as it came in and went out of Declaration DAO. Further, even if there was some regulation that had to be made here, it is outside of the scope of the SEC. And that is because Bitcoin and Ethereum have been publicly declared a commodity by both the FTC and the SEC. And to say otherwise would disrupt the balance of these federal agencies. And the reason why this token is actually similar to Bitcoin and Ethereum as a commodity is because at the time that Bitcoin and Ethereum were created, they were self-mining, or in other words, self-regulating. And here, DAO is structured to be run by algorithms and smart contracts executed on a blockchain rather than through the active decisions of human beings. And this is the definition the SEC provided on page 4 of the record. So in other words, it's designed to be self-regulating. Custodians just oversee the ether and they help advertise Declaration DAO's purpose.
Counsel, what's the practical implication, both in this case and cases going forward, if we adopt your reasoning here?
Justice Newman, the practical implication is that those products which have primarily a consumptive motive would be able to go on without regulation by the SEC and therefore not hinder the free market. To hold that a token which has a primary consumptive motivation as a security would disregard this court's precedent. It would expand the act beyond Congress's intent and the authority of the SEC, which would in turn hinder innovative groups such as Declaration DAO from offering creative options to society. Therefore, this court should reverse the 13th Circuit to protect a purchaser's ability to consume a product. Thank you.
Okay, counsel, one last question. The primary purpose is exactly what you stated, but over time, and the record talks about it, there could be secondary buyer. There's a market out there. Does there come a point where your argument no longer holds water? Perhaps in your case, you're going to argue, yes, it continues to hold water, but can there be an argument at some point that there's so many secondary purchasers that this is regulated by the SEC?
Chief Justice Helpe, this court in SEC versus Howey stated that the relevant time period is the time of the sale, so the initial sale. And that is what is determining what the donors expected and whether there would be profit or consumptive motive at that time. Thank you.
Okay, thank you very much. Okay, let's proceed with the next counsel.
Thank you, Chief Justice. Chief Justice, Your Honors, and may it please the court. My name is Tyler Gustafson, and I also represent the petitioner, Mr. Chad Saylor, in this matter. In the event that this court finds that there is a security at stake here, petitioner still prevails. What is at stake today is the overall disposition of securities markets. If this court chooses not to require culpable participation in pleading a case for control person liability, business people will be more hesitant to engage the markets, killing the entrepreneurial spirit that causes economic growth. This court in United States versus Stein held that the anti-fraud provisions of the Exchange Act must prevent rigging of the market and permit operation of the natural law of supply and demand. When the wrong people are held liable for unfortunate wrongdoings, more injustice and victims abound, hindering securities markets and the economic freedom of those interested in such markets. Therefore, the 13th Circuit erred when it held that the SEC does not need to plead culpable participation for control person liability because, one, the plain meaning of the statutes show that participation is an element of control person liability to be pled by the SEC in these matters. And two, congressional intent only demonstrates the same for such a prima facie case. Preliminarily, it is undisputed that Twombly and Iqbal necessitate that a plaintiff must allege facts plausible on their face and state the elements of their claim in conjunction with those facts that go beyond mere naked assertions. What is at issue here, then, is whether or not the Securities Exchange Act of 1934 makes culpable participation an element of such control person liability.
Okay, counsel, but you realize there is a split. There's district courts going one way, there's district courts going the other way. And there are some circuit courts who have opined, nothing in the 13th Circuit. So what makes one argument of one particular group of courts, the rate ratio decidendi, better than the other group of courts?
Chief Justice Helby, that gets directly into my second point. And obviously, as you stated, when there is circuit courts who interpret a statute differently, there is some level of ambiguity, as this court noted in Wooden versus the United States in a very recent case of this year. On top of the plain meaning of Section 20A, congressional intent also supports the fact that culpable participation is an element of control person liability to be pled in order to establish a prima facie case. So going to that congressional intent, Chief Justice, in Lanza versus Drexel Company in the Second Circuit and Roches versus Rhodes in the Third Circuit, both cases dive deeply into congressional intent. And each case in each of the respective circuits, the Second Circuit notably holding the New York City and the New York Exchange Commission, congressional intent demonstrates that Congress wanted something more than insurers' liability for control persons. Thus, Congress passed what is a fiduciary standard for control person liability.
Counsel, before you even go further, perhaps it'd be helpful to provide the proper framework here. I mean, what's even the standard of review that we should be applying with respect to this issue?
Here at issue, Your Honor, we are dealing with a motion to dismiss. Thus, at this stage, what the plaintiff must plead are facts plausible on their face. And here, the SEC has not done that because it has not even alleged all of the elements of their claim.
I'm sorry, counsel, what's the standard of review though? This is an appellate issue now. So I understand that the procedure started as a motion to dismiss, but you're asking us to review whether the pleading standard is one that has to include this culpability standard. So what's the standard of review that we as the Supreme Court should be applying to this issue?
De novo review, Your Honor, if I'm understanding your question correctly.
Thank you.
So then going back to Chief Justice Helpy's contention about congressional intent and being ambiguity in what is applied to Section 20A, those two cases, Lanza and Roches in the Second and Third Circuits respectively, demonstrate Congress wanted something more than insurers' liability. And importantly, Your Honors, during congressional hearings and congressional debate on passing Section 20A of the 1934 Exchange Act, the House proposed something along the lines of a fiduciary standard. The Senate, on the other hand, proposed an insurer's liability standard, which petitioner may argue for. That insurer's liability standard looks much more like common law respondeat superior or vicarious liability and subjects control persons to almost unhinged liability in these situations. But what Congress did was pass the fiduciary standard in which the plaintiffs must plead control person liability with culpable participation. And Thomas Corcoran, a principal drafter of Section 20A, stated that the section's purpose was designed to prevent control persons from acting as puppeteers behind the scenes.
Counsel, what position are you advocating that we take here? What do you think would be the appropriate standard?
Your Honor, in Ernst & Ernst v. Hochfelder, this court noted that culpable participation requires something more than negligence. As petitioner sees it, there are 4 ways by which this court could handle culpable participation, but it's petitioner's stance that this court ought not require, need not decide what that exact standard is today. The SEC did not meet any standard beyond simply alleging control over a primary violator. And those other 3 standards then, Your Honors, are something more than negligence, recklessness, or a form of scienter, as this court noted in Ernst & Ernst v. Hochfelder.
Counsel, let me just ask you this. This is about 20A. Do you have a concern that if we adopt your position here, that this will make it more difficult for the SEC to enforce the area that it has been charged to enforce? Specifically, is it going to make it tougher for the SEC to get to people that are doing things they shouldn't be doing?
No, Your Honor, and that jumps back into the plain meaning of the statutes and my first point of this argument. Sections 10B versus sections 20A deal with 2 different groups of folks that deal with securities fraud. Section 10B deals with those primary violators who directly have their hands on the manipulative or deceptive devices of fraud. Section 20A gets to those folks who act as puppeteers behind the scenes, who use those primary violators to engage in securities fraud. Thus, this court will not be hindering the SEC's ability to go after those persons because Section 20A directly addresses that second class of people.
Wasn't 20A adopted to expand the group of people that the SEC could go after? So isn't your argument undermining the very purpose of Section 20A?
Well, Justice Hafen, if we can turn to the plain meaning of the statute itself, let's first start with the definition of control in Section 20A. At the time that the 1934 Exchange Act was adopted, control had a very active definition, and that active definition stated to exercise restraint or direction over, dominate, or command. And this indicates that control had an active element beyond merely addressing one's position and acknowledging the actions that a control person takes. And as this court noted in Kmart Corporation versus Cartier Incorporated, courts must look to the ordinary statutory language in conjunction with the language and design of the entire statute at issue. Furthermore, Your Honors, in Russello versus United States, this court noted that when Congress uses one set of language in one section, but a different set of language in another, that is demonstrative of the fact that Congress knew what it was doing. As the Second Circuit notes in Lanza versus Drexel and Company, throughout the Exchange Act of 1934, the words cunning, manipulative, deceptive, fraudulent, illicit, fraud, and lack of good faith manifest that culpability be present, pleading control person liability. Here, it's also important to note the differences between the Securities Act of 1933's control person liability section, which is section 77O, subpart A, comparing that to the Exchange Act of 1934's control person liability section in 20A. In 77OA of the 1933 Act, Congress created liability where there is for control persons when they negligently controlled persons. And that was subject to a clause unless the controlling person had no knowledge of or reasonable ground to believe in the existence of the facts by reason the controlled person committed fraud. And this court in Ernst & Ernst v. Hochfelder noted that that 1933 Act created such a negligence or insurer's liability standard, but that Section 20A required something more than negligence to be pled for a Section 20A control person liability case to be made. And recall the pleading standards of Twombly and Iqbal. This court noted in United States v. Menachie that it must give effect, if possible, to every clause and word of a statute. Further, in Rubin v. Islamic Republic of Iran, this court noted that statutes must be construed so that effect is given to all its provisions and so that no part will become inoperative. And such effect and operability are applicable here, as culpable participation is an element of control person liability. As the Third Circuit notes in Belmont v. MB Partners Incorporated, simply alleging sloppy compliance is not enough to establish culpable participation in this context. Your Honors, respondent may also couch its argument based upon the language of Section 28 and that last clause, where the last clause is set apart by a comma and the word unless. And respondent may argue that that means that this is an affirmative defense, and that the title of the statute itself may even say that it's an affirmative defense. However, it's important to note that this court has noted such titles of statutes should not bind the plain meaning of the statute itself. And in the Exchange Act of 1934, Congress was very clear when it made affirmative defenses an option for liability. In Section 16C of the Exchange Act, which includes substantially similar language to Section 18A of the Exchange Act, both sections have similar words to but and unless, but both sections include the word proves, clearly indicating an affirmative defense. What is missing in Section 20A is that word. Thus, it is not clear that Section 20A creates only an affirmative defense. Section 20A's good faith provision subject to a person directly or indirectly inducing the fraud is an element of control person liability for these reasons, Your Honors. Speaking back to congressional intent in my second point, Congress intended to promote economic activity by protecting control persons from liability for the bad actions of others. And as the Second Circuit and In re Alstrom noted, imposing only a negligence standard for control person liability could have a chilling effect on the willingness of persons such as outside directors to serve where those persons are typically not involved in the day-to-day affairs of the company. Your Honors, for control person liability, culpable participation is an element. And winter stands at the door of economic freedom and production if this court does not accept that culpable participation is an element pled for control person liability, threatening to chill both American values. Because both the plain meaning and congressional intent behind the Exchange Act require culpable participation to be pled, this court should overrule the 13th Circuit and grant the motion to dismiss. Thank you.
Thank you very much, counsel. We're now going to hear from the other side, Counsel McDonald. Your turn. Please proceed.
Chief Justice, Your Honors, and may it please the court. My name is Hannah McDonald, and my colleague Ms. Fareshtaku and I represent respondent in this matter. This case is about affirming Congress's intent to protect innocent investors from securities fraud. Indeed, here, investors lost $378 million. Respondents respectfully request that the court upholds the decision of the Court of Appeals to protect the rights and claims of Declaration DAO's investors who were wrongfully harmed in this case. We will now address each of the issues. This court in Howey noted that Congress intended to have a broad definition of security to protect these innocent investors. This was more recently reaffirmed by this court in SEC v. Edwards, where it noted that the Howey court's desire to have a broad test that will encompass all securities that is flexible so that it can adapt to the countless and variable schemes that may target investors. Here, the court should find that the WTP tokens are securities because all aspects of the flexible Howey test are met. I'll start with the third prong as my colleague here has done.
Counsel, can I ask you, are you in agreement with your opposing counsel that there's three prongs? As I understand it, some courts say there's three, some courts say there's four prongs.
You're correct, Your Honor. Either way, I will address each of the sort of two aspects at the end that are sometimes considered one element and sometimes considered two, but I will address each.
And counsel, before you do that, as I asked opposing counsel, which prongs do you concede? I guess your position is all prongs are met. Am I correct?
Correct. All elements are met, and this is an element test, not a factor test, and so all do need to be met here by respondent.
Okay.
Looking at the third issue or the third and fourth issue, depending on how the courts look at it, we're looking at an expectation of profits by the investors that was they were led to believe there would be this expectation of profits because of the managerial efforts of the promoter. There are three different ways here that the investors were led to believe there was an expectation of profits. The first, by ownership of the declaration itself, which is a speculative asset. The second, by the explicit language in the white paper about future business ventures. And the third, because of the secondary market. It's important that this court remembers that it has decided in Foreman that we need to look at substance over form, and we cannot be distracted by certain statements that act as a sort of smokescreen for the economic realities in this case. Just as in Foreman, they claimed that the item at issue was stock, they found the economic reality was that it was not like stock. And here we have to understand that just because token holders or investors were called donors, that does not mean that these were actually donations in this case, or that this was actually even a nonprofit. The petitioner spoke about consumptive use, and this court in Edwards has clarified that there is a difference between consumptive use and expectation of profits. However, there is no consumptive use here. In Foreman, we saw that the stock at issue got you the right to live in an apartment. Petitioner has also spoken about homes or pieces of art. It is obvious how those three things are all used or consumed by the investor in that case. However, here, these are tokens. There's no claim that the token holders or the investors would ever have the right to hold or use the declaration or be able to use this token in any sort of real meaningful consumptive way. This case is very distinguishable from those use or consumption cases.
Are you suggesting that declaration DAO is a for-profit entity?
It is unclear at this stage without discovery, Your Honor. We do admit that in the complaint, we have stated that they formed themselves as a nonprofit. However, the economic realities behind that show that something very different could have been happening. Indeed, when they resold their tokens that were returned after the declaration was not purchased, when they resold those tokens, they made $105 million. And there was significant ways that the token holders themselves were also earning money. And so the substantial economic reality here needs to be looked at over the sort of smokescreen or lip service that they were paying to try and evade securities law. Indeed, the record shows that petitioners were aware of the SEC's DAO report, which said that these very well may be securities, and they ignored that risk and did not register.
But counsel, let's assume that Declaration DAO was a nonprofit. As I'm sure you know, nonprofits can generate income. The question is, what do they use that income for? And we know, per the record, that Declaration DAO did tell the donors that DAO's sole purpose was not to make money. How does that change your analysis?
Does not, Your Honor. It's important that this court realize that a creative promoter trying to evade securities law cannot mean that this case just is passed off with a motion to dismiss. When we look at the white paper itself, we see specific statements promoting the appreciative value of the tokens themselves. The white paper emphasizes the finite number of tokens and that any tokens not sold in the initial coin offering would be burned, further leading to scarcity, the possibility of burning any refunded tokens, the explicit secondary market, and this is explicit language about next business ventures. And so it would be very dangerous for this court to claim that just because a promoter says, we don't want to make any money, that suddenly all these cases can just be passed off with motions to dismiss when investors lost $378 million. This is very significant. We also see, when we look at the declaration itself as a speculative asset, that in 1988, it sold for $165,000. It was then valued at the time of this initial coin offering to sell for $15 to $20 million, and indeed did sell for $60 million. And so investors reasonably and objectively could have believed that they would be able to make money with purchasing into this declaration DAO, because the white paper promised a fractionalized ownership token in the white paper found on page 6 of the joint appendix.
Counsel, let me just, push you a little bit on that. Obviously the group ended up not acquiring this copy of the Declaration of Independence. But again, if the Declaration of Independence were acquired, if it had been acquired, assume that for me, wasn't the purpose to hold it for the benefit of the people rather than reselling it at a profit? And if that's true, how does that impact your analysis?
It does not, Your Honor, because the option of the secondary market means that that's not completely true. Those claims are not completely true. They claim that the people will have the right to hold the declaration and not make any money off of it. But new original copies of the declaration will not be created. And so the price, the value of the declaration is only going to go up. And the secondary market allows for these token holders to continue to resell their fractionalized ownership interest to continue to make money off of this. And so it is still a significant expectation of profits for the reasonable investor. We also note here that in SEC v. Hugh Fang, in that case found that investors' expectation of profits did not need to be the singular motivation or even the primary motivation for an expectation of profits to still be present and to meet this element of the Howey test. And so it is insignificant that while people may have had a joint interest in democracy, that they were not also led to expect profits. It is also important to note here that 75% of the token holders held on to their tokens after the declaration was not purchased, interested in being able to participate in this next business venture, as specifically advertised on page 7 of the joint record in the white paper. I'd also like to clarify petitioner's point. There was no other language surrounding next business venture. There was no claims in the white paper that these next business ventures would be looking to buy a replica of the Liberty Bell or anything similar. It is just the language next business venture. And so there's, without any sort of couching or limiting phrases there, it's not reasonable to expect that the investors would not see that language for what it is, which is an expectation of profits. It leads me to the second half. Yeah.
Counsel, so to be clear, are you suggesting that even if the initial motive of the donors or the investors was consumptive, that even the white paper confirms that that motive could change because in this secondary source, they may have been able to purchase something other than the Declaration of Independence?
They did not even need to purchase something different. It was just a next business venture. However, we do see there is case law emphasizing that when the consumptive use is not actually available at the time of distribution, it does not relieve an enterprise from needing to register as a security because that consumptive use was not a guarantee. As you pointed out, I believe this was an auction. And so at the beginning, when purchasers purchased in, there was definitely a risk of expectation of profits or a risk of loss because the ability to have the declaration was not even there at the beginning. It brings me to the second half of the prong here, the managerial efforts. And we see that in Albanese versus Florida National Bank, the court held that insubstantial or illusory control in the hands of the investors was actually evidence that the profits were dependent on the promoter. That was a case regarding ice machines where the investors did not have the knowledge on how to repair ice machines or collect the profits or handle the different managing of these machines. It's very similar in this case because while it is true that the white paper is explicit that the token holders would have the right to propose community proposals to perhaps direct where the business may go, the white paper is also explicit that this needed to be accompanied with the requisite coding. And coding is a significant technical skill that the average investor does not have. And without that skill, it is actually illusory or insubstantial control that they are offered. Without the coding, they cannot make any proposals and there's nothing they can do to suggest where the business will go. We also see in Fidance v. Harris, which is an 11th Circuit case, that there's a finding that digital token holders relied on the promoter just in even creating the non-existent platform, which is also present. Here, the managerial efforts were undeniably significant, and they were not just ministerial. The custodians received and stored the ether. They maintained the source code, which kept the smart contract running. They marketed the WTP tokens and increased their value. They handled all of the ordinary business transactions. They were in charge of the security system, which protected, or in this case, failed to protect the value of the tokens. And they had the complete choice on whether to resell or burn refunded tokens. And they did resell the tokens and then further promoted what a good idea this was because it provided additional funding for future business ventures. And so the execution of the core functions here are really centralized, even though there are some claims in the white paper that they're decentralized. And again, we urge you to look at substance over form. It is impossible in this case to see that the substance is not an expectation of profits. I'll briefly touch on common enterprise as my colleague here did. I agree with the classification that the 13th Circuit has looked to vertical commonality, and the question at cert is not that this issue, that this court needs to decide which type of commonality is necessary for the common enterprise prong. However, the core element of vertical commonality is investment without the investors desiring to perform any of the work themselves or the necessary chores to bring about a return on their profits. And this brings us back to this coding issue. They had no opportunity to ever bring about their returns because they had no ability to actually perform the chores necessary. It's very similar to the Eberhardt case and very similar to the ETS payphones case, which is the kind of co-case to this court's decision in SEC v. Edwards, where ETS had all of the managerial efforts and investors had none. So we ask that this court please find that the WTP tokens at issue are a security. Thank you very much.
Council, one last question. I don't want to interrupt you. I asked the same question of Mr. Gustafson. There's definitely a secondary market out there. And he responded that you have to look at the time of the initial offering, not at what happens later. What is your position as to that secondary market?
The secondary market was specifically created by the petitioner in this case and promoted in the white paper. And so it is still an element that was a suggestion of expectation for profits at the very beginning, because that secondary market was a promotion and part of the promotional materials at the beginning. Thank you.
Thank you very much, Ms. And I know it's Hannah also, so if you can pronounce your last name so I don't mispronounce it, and your turn. Thank you.
Thank you, Chief Justice. And Chief Justice, Your Honors, may it please the court. My name is Hannah Fareshtaku, and on behalf of respondents, I will be addressing the second issue, that the SEC is not required to plead culpable participation when alleging a secondary violation of Section 10B of the Exchange Act. This issue is about giving a statute the meaning that Congress intended when it passed legislation to protect innocent investors. This is fundamentally a question of statutory interpretation, and accordingly, we know that the SEC is not required to plead culpable participation for three reasons. First, because of the text of Section 20A, that is the basis for secondary liability in the Exchange Act. Second, because of the legislative history. And third, because of the structure of security laws. So first, we start with the text, as this court has affirmed time and again, including in Ernst and Ernst versus Hochfelder. And we know from Ernst and Ernst that the text of 20A does give rise to a state of mind requirement that is something more than negligence. But this court left open where in the statute that arises from and who has the burden to show it. Now, petitioner did not point to any specific language in 20A from which the culpable participation standard flows from that they are advocating for. So we have to review the language of 20A to determine where is the state of mind requirement that the court identified. And when we do that, we see that first, the elements of control person liability are, as stated, every person who directly or indirectly controls any person liable under any provision of this chapter shall also be liable. Those are elements of control and a primary violator, neither of which have an element of a state of mind or culpability. The SEC has defined control as simply the possession of the power to control, and that's what the majority of circuits have also adopted, even culpable participation circuits like the Second District or the Second Circuit in SEC versus First Jersey Securities. So we continue and see that Section 20A says that the controlling person is liable unless the controlling person acted in good faith and did not directly or indirectly induce the act or violation. This must be the language that the court recognized gives rise to the state of mind requirement, because the terms good faith and inducement are legal terms of art that inherently imply a state of mind and culpability. The question then is, who has the burden to show the state of mind or a lack of the state of mind? And we must conclude that it is the defendant who has to show a lack of the state of mind, because Congress wrote this requirement as an affirmative defense. And we know that for several reasons. First, because of the title of the statute, which plainly says that it is joint and several liability, good faith defense, indicating that Congress very intentionally was creating an affirmative defense. Now, while petitioner pointed to other portions of the Exchange Act where Congress created an affirmative defense by saying that a defendant has to prove the state of mind, that's not dispositive here, because first, this court has recognized in Ernst and Ernst that Congress fashioned the state of mind and grounds for fault of the civil liability in the Exchange Act on a particularized basis. And so we have to look at the text of the individual statute creating that basis. So we have to look at 20A and what Congress wrote in 20A. And furthermore, because there's more than one way for Congress to create affirmative defense. There's no requirement that they have to say that a defendant has to prove something. And in fact, the plain language of 20A is written in an affirmative fashion. It says that the controlling person is liable unless the controlling person acted in good faith and did not induce the violation. That's language that is an affirmative showing of good faith and lack of inducement, something that a defendant can make an affirmative showing of. If it were a plaintiff's burden to show as an element, as opposed to an affirmative defense, we would expect it to read something like, every person who controls a primary violator is liable if they also did not act in good faith and did induce the violation. So the plain language.
Sorry,
Yes, John.
Counsel, can I just stop you right there? I want to go back to that same language that you just cited from in 20B, acted in good faith and did not directly or indirectly induce. I understand your argument that seems to suggest that the burden should be placed on the defendant rather than the SEC, but doesn't that same language also suggest that there should be conduct by the defendant that would give rise to 20A liability? The concern that I would have here is that essentially what the commission is trying to do is make one employee an insurer for the conduct of all of the other employees. And for example, if you have misrepresentation claims under the existing federal securities laws, in order for an individual to be culpable, they have to have participated in that misrepresentation. The facts here, we have a defendant who didn't know about the security breach, directed Reynolds, let me know if something like this happens. There's no evidence of any misconduct at all. So if you change the law or create a law the way that you're suggesting, and I know I'm giving you a lot to unpack here, but this feels like from a policy standpoint, it's going to have a huge chilling effect on people wanting to be officers and directors of companies because they have to be an insurer. How would you respond to that gigantic package of questions?
I see your concern, Honor, about a potential chilling effect, but that language that you pointed to about inducement, it goes hand in hand with the language that Congress included about acting in good faith. So in order for a defendant to avoid liability, they have to also have acted in good faith along with not participate or not induce the violation. And so that prevents the concern of a chilling effect, because as long as a defendant is able to have these systems in place to maintain and ensure that there are no violations, they shouldn't have a concern, and they don't actually get involved in any violation or induce a violation. They should have no concerns about being involved with their company. So Congress's language that they chose is a policy decision that this court has to give meaning to. And the policy decision they have made is to require defendants to act in good faith and not induce the violation. That doesn't mean that they can't participate in their organization and be a member of it and drive it, but they have to make sure that they are aware of what's going on in their organization and not induce a violation. That shouldn't chill any investor or any director from getting involved. And this is the conclusion that, as Chief Justice Helpy pointed out, what the majority of circuits have also concluded, that Congress did not require a plaintiff to plead culpable participation. In fact, the Ninth Circuit in Hollinger versus Titan Capital abrogated a previous line of cases that had been requiring plaintiffs to plead culpable participation, and determined that actually the correct reading of the text is that it's an affirmative defense, not something that a plaintiff has to plead. But even if you find the language to be ambiguous, my second point about the legislative history compels concluding that Congress did intend this to be an affirmative defense. That's because we see from the legislative history that the Senate was concerned when it passed controlling person liability about individuals and preventing individuals from evading liability through dummy organizations or proxies. So as Justice Hafen pointed out, this was an intent to expand the scope of liability and prevent evasion from liability. And this is consistent with legislative history that petitioner pointed out about concern for puppeteers. In fact, the higher pleading standards that petitioner is advocating for would make it more difficult for a plaintiff to reach any individual who's acting as a quote puppeteer, because if they're such a manipulative and deceitful individual to be pulling strings from behind the scenes, they also wouldn't have left evidence for a plaintiff to find about culpable participation. And so that higher pleading standard is inconsistent with legislative history about a concern for puppeteers and a concern for expanding liability. And as in regards to the fiduciary standard that petitioner mentioned, this affirmative defense is consistent with creating a fiduciary standard of liability as opposed to strict liability. It gives a right for defendants to exculpate themselves by demonstrating that they have acted consistent with what Congress has legislated. And to the extent that petitioner relies on cases from the Second and Third Circuit, such as Lanza and Roach's Brothers, those cases primarily rely on the legislative history as opposed to reading the plain text of the statute. And a lot of the legislative history they rely upon is from 10B, not 20A. That's an inappropriate source of information to determine Congress's intent for 20A. First, because again, as this court recognized in Ernst and Ernst, Congress fashioned the standards of fault on a particularized basis, so we can't import the standard of fault from 10B into 20A. And because 10B is a primary liability statute, where 20A is a secondary liability statute. Secondary liability in other areas of the law is also a mechanism to expand the scope of liability. So it's not logical to assume that Congress's intent with a primary liability statute is the same as its intent for a secondary liability statute.
Let me ask you, isn't one of the various tests of statutory interpretation, if the language is not 100% clear, and it's, in this case, I believe it isn't because there's a split, can't we look, one of the tests is to look to analogous statutes? Isn't that what your opposing counsel is suggesting?
Respectfully, Your Honor, I would argue that 10B is not necessarily an analogous statute, again, because it is a primary liability statute. It would be more appropriate to look to the legislative history for another secondary liability statute in the Securities Act. But when you do that, it doesn't change the conclusion that the legislative history for 20A supports, that there is no culpable participation requirement. And as to my third point, that the structure of securities regulations also compels concluding that the culpable participation is not a pleading requirement. As petitioner said, this court has to give meaning to all sections of a statute so that no section is rendered superfluous or unnecessary. But this higher pleading standard that petitioner is advocating for in section 20A could collapse the distinction between primary liability in 10B and secondary liability in 20A. If a plaintiff has to plead culpable participation, essentially some degree of participation almost bordering on intent, that would eviscerate the distinction between 20A secondary liability and 10B primary liability.
So let me take you back just a moment ago. You were talking about legislative history. If we don't look at legislative history, do you still prevail in this argument?
Yes, Your Honor, because the plain language of the statute is clear that it is written in this affirmative fashion, making it an affirmative defense. But if you were to find that it's not clear, and so there is a culpable participation requirement, you should hold that culpable participation requirement is still not a stringent pleading standard, consistent with what the Second Circuit, a culpable participation jurisdiction, has also held. A district court in the Second Circuit in re WorldCom conducted a review of Second Circuit cases and found that first, culpable participation is actually generally applied as a prima facie element of a case at trial, not a pleading standard. But when it was applied as a pleading standard, it wasn't a state of mind requirement. All that a plaintiff had to plead was a degree of control sufficient to render a defendant liable. And the Second Circuit held in the case Suez Equity Investors versus Toronto Dominion Bank that the pleading that was sufficient to show that degree of control and meet a culpable participation pleading standard was when a plaintiff pleaded that the defendant was the officer of the bank and had primary responsibility of the bank and over the defendants. And the SEC here, while I would respectfully remind this court that the only question on cert is what is the pleading requirement, the SEC has pled sufficient facts to even meet that standard, the Second Circuit's culpable participation standard. Because on page 3 of the record, the SEC has pled that Petitioner Saylor is the co-founder and co-CEO of Declaration DAO, so he is an officer of the organization. On page 5 and 6, the SEC has pled that he was in a contractual third-party contractor relationship with Reynolds, so he was in control of this individual, and that Reynolds specifically was required to report to Saylor and only Saylor and his co-CEO, so they were primarily responsible for Reynolds. And we know from page 5 of the record that the reason Petitioner hired Reynolds was to draft the source code and manage the crowdfunding platform to store and retain the cryptocurrency received for the tokens, which demonstrates that Petitioner was overseeing the daily maintenance of Declaration DAO.
So even you just reminded us of the issues that are before us, right, at this appellate level. So are you conceding them by the fact that you pled facts sufficient to show that the defendant culpably participated in this alleged fraud, that culpability is in itself a standard that does have to be pled for purposes of the act?
I am not conceding that, Your Honor. What I'm explaining is that if this court were to find that for some reason that question should be reached, even under what the certified question is, that you wouldn't have to remand for any determination about the sufficiency of the complaint. But indeed, what would be most appropriate if you were to find that a different pleading standard applies would be to remand. And but even then, the SEC would be able to show to the district court that we have sufficiently pled facts that would show culpable participation. And the reason the SEC has already done that, even though it's not a pleading standard, is because, as I mentioned, the Second Circuit has demonstrated that culpable participation is about control, which is already the primary element necessary to be pled under 20A. So circuits that have been applying culpable participation seem to be conflating these elements and these definitions. So even under this alternative argument, if you were to find that culpable participation is required, the SEC has pled that. But because of the text and legislative history, it's not required. Yes, Your Honor. Sorry, you're on mute.
Doesn't that just show that the word control then is in itself ambiguous, with the fact that there has been this conflation of the terms of control and culpability, et cetera?
I don't think it's ambiguous, Your Honor, because of the SEC's definition, which is a reasonable definition based on the overall statute. But again, even if you were to find it to be ambiguous, we have that pleading requirement as well. I see my time is up, Your Honors. So thank you for your time.
Thank you very much, counsel. We now have, I believe it's 2 minutes of rebuttal. So let's proceed. Ms. Phillips.
Yes, Your Honor. Chief Justice and Justices, I have 2 points on rebuttal. First, according to this court in Howie, Edwards, and Foreman, level of speculation is not part of the analysis. And even if it were part of the analysis, this organization was too speculative since the winning of the bid was never guaranteed. The record does not state anywhere that the secondary market was created by the custodians, and any profit created was due to market fluctuations on secondary markets by token holders. Second, petitioner is not advocating for a heightened pleading standard. Petitioner advocates that the SEC plead the elements of their claim that are plausible. In Montclair v. Ramsdale, this court stated that it should not construe language to mean that Congress was not ignorant of the language that it used. And contrary to respondent's contention in Hochfelder, this court explicitly stated that Section 20A is a state of mind provision. The title of a statute is not dispositive on the substance of a statute. And contrary to respondent, petitioner uses proper legislative history that is in line with Section 20A. The principal drafter of Section 20A stated that the aim of 20A is to catch the puppeteer behind the scenes. The WTP tokens are not a security and fall outside of the 1933 and 34 acts. Therefore, we respectfully ask this court to reverse the 13th Circuit. Thank you.
Thank you very much. The case now stands submitted. Thank you very much, all.
All rise. The Supreme Court of the United States is now in recess. Competitors are asked to step out of the courtroom while the justices complete their score sheets. We will invite the competitors back into the courtroom for commentary once the scoring has been completed. Thanks, everyone.